Hello, everyone. I'm Alex Grant, and welcome to Immigration Update Desk. Here's what is happening beneath the headlines and why it matters far beyond one city or one family. A growing number of people who are fully inside the legal immigration system, documented, trackable, married to U.S. citizens with petitions and even adjustment applications on file, are still being swept into immigration enforcement after routine encounters that used to be uneventful. And the main case that sparked this discussion is a window into how two parts of the federal machine can collide in a way that leaves families shocked, confused, and suddenly fighting detention even while their green card cases are active. The reported facts are simple and jarring at the same time. A U.S. citizen says her husband, a Brazilian national who came to the United States seeking asylum, married her, and in 2024 entered the standard marriage-based process when she filed to sponsor him for permanent residence, was taken into Immigration and Customs Enforcement custody after what began as an ordinary traffic stop in Portland. This wasn't a border arrest or an ICE raid or a missed interview. It was a stop on a regular street. Police initially thought he was someone else. He identified himself, and instead of being waved on, he was handcuffed and ICE stepped in. In minutes, a green card applicant married to a U.S. citizen with an active case in federal systems found himself in detention, and no detailed public explanation accompanied the arrest. No list of criminal charges, no narrative that would match traditional priority language, just the lived reality that one moment he was driving to a destination like any of us, and the next, he was inside the federal enforcement pipeline. Immigration lawyers from other regions immediately recognized the pattern because they have been seeing it more often than they did a few years ago. Foreign spouses of U.S. citizens detained during or after marriage interviews, snagged following everyday police encounters for minor traffic issues, or picked up at check-ins while their I-130 or even I-485 is pending, and their only potentially removable facts are civil: an entry without inspection years ago, an overstay long since disclosed, a missed hearing in the past that was never explained, or a previously unknown in absentia order that surfaces when fingerprints or name checks are run. Historically, immediate relatives of U.S. citizens in active processing were treated with a kind of procedural buffer. Nobody promised immunity, but the practical logic was that a person who is actively seeking permanent status through a U.S. citizen spouse who is appearing at USCIS appointments and uploading documents to the National Benefit Center is not evading the system and poses no reason to be detained while the government itself evaluates eligibility. In 2026, that assumption is no longer safe. The federal government has expanded interior enforcement and local initiatives with names that sound targeted, catch-of-the-day style operations that officials say focus on serious offenders, are intersecting with people already in the legal pipeline because databases do not partition the world neatly into priority criminal and active applicant, and because under the statute a person with a technical ground of removability can be placed in proceedings even if a green card case is moving. That's the structural clash. USCIS is sending messages that say, come forward, file, attend, trust the process, while ICE and ERO operate under a rule set that says, if a person is removable, we can act now. And when those logics meet, they sometimes collide inside a family. To see how that collision is possible and to prepare for it, you need to understand the legal architecture under the surface. A pending I-130 petition, or even a pending I-485, does not by itself confer lawful status or grant immunity from enforcement. The Immigration and Nationality Act draws a bright line between eligibility to apply and the separate question of whether a person is currently admitted or in a lawful non-immigrant classification. Someone who entered without inspection cannot adjust inside the United States through INA 245A without a grandfathering basis such as INA 245I or a form of parole. including parole in place for certain military families, or a lawful admission at some point. For example, a prior inspection with a visa or an advance parole entry that counts as a form of parole for adjustment purposes, and even spouses of U.S. citizens who receive forgiveness for unauthorized employment or simple overstays still need that threshold admission or parole. The law has always said that a person who is removable under INA 237 or inadmissible under INA 212 can be placed in proceedings even while an application is pending, and that discretion, present on paper for decades, is what is now being exercised more frequently in the interior, not only at the border, but at traffic stops where fingerprints link to DHS systems, at USCIS buildings where interviews sometimes lead to ICE referrals if an old removal order is discovered, and at home visits when ERO teams seek to execute final orders that were issued long ago. Many families learning this for the first time feel like the social contract of legal immigration has cracked because the promise of "do it the right way" is colliding with the reality that the very act of doing it can expose the applicant to enforcement. From the government's perspective, officers point to statutory duty and updated priorities. If someone is technically removable because of a prior order, a false claim to citizenship, a controlled substance offense, a fraud finding, a re-entry after removal, an entry without inspection with no adjustment path, or certain national security flags, they argue that acting on the case is a lawful application of Congress's rules and is not an indictment of the marriage. That's the letter of the law view. But from the vantage point of a mixed status household, the distinction is fragile because the process feels like a trap. You voluntarily disclose everything to USCIS. You appear for biometrics and interviews. Your U.S. citizen spouse signs a binding affidavit of support. You wait months or years while fingerprints and names circulate through databases, and then a traffic stop, a courthouse hallway encounter, or a routine follow-up becomes the moment removal powers are invoked. That's why you're hearing seasoned immigration lawyers change the way they advise, not on whether to tell the truth on forms, that never changes, but on risk management around logistics, whether to bring the non-citizen spouse to an interview without counsel present, whether to request a virtual or separated appearance if local field offices allow it, whether to arrange a same-day bond strategy in case proceedings start, whether to carry documentation that proves a clean criminal history and eligibility for relief, whether to drive across county lines where 287G agreements exist between local law enforcement and federal immigration authorities, what to say and not say if a primary stop leads to a secondary immigration hold, and which rights to exercise calmly at the door if officers knock without a judicial warrant. That advice is not about avoiding the system, it's about interacting with it intelligently in a year when internal handoffs are more likely. What can trigger detention for someone with a pending marriage case is often a piece of history that either wasn't known or wasn't understood as a risk. An in absentia removal order issued years ago when an address wasn't updated properly, or a notice was mailed to the wrong place, a prior voluntary departure that was not timely executed and then converted into a removal, a minor criminal case that under state law looks dismissed, but under immigration law still counts as a conviction, or contains elements of a crime involving moral turpitude, a misstatement on a border form or visa application that now appears as misrepresentation, or simply an entry without inspection that leaves no lawful pathway to adjust status inside the country without 245I grandfathering or parole. When such facts surface, ICE can arrest, and the Office of Chief Counsel can file a notice to appear in immigration court even if the I-130 is approvable, because the court's first task is to decide removability. At that point, several tracks become possible. Counsel can ask the trial attorney to exercise prosecutorial discretion, to dismiss or close the case without prejudice, so USCIS can adjudicate the pending adjustment. A judge can grant a continuance, so the I-130 can be decided first, and then potentially terminate for USCIS to adjudicate the I-485. The non-citizen can request bond from an immigration judge if eligible and present strong equities, or if there is a final order in place. Counsel can file a motion to reopen based on lack of notice, changed circumstances, or legal developments, and request a stay of removal while the motion is pending. None of these are guaranteed, but they are real tools, and people win every day when facts and preparation support them. The challenge in 2026 is timing. Events unfold faster, and families without a plan find themselves playing catch-up. If you're in a marriage-based process today, triage your facts with brutal honesty before an interview or a cross-country drive. Confirm how you last entered the United States and whether an admission or parole exists in your record, because that determines whether you can adjust inside under 245A. If the only path is consular processing with a provisional unlawful presence waiver, I-601A, understand that arrest or placement in removal proceedings can automatically revoke that provisional waiver and force a different strategy. Pull your FBI identity history summary and, if needed, request a copy of your immigration file, FOIA, to check for old orders or records you may have forgotten or never received. If you discover an in absentia order, do not attend an interview without discussing a motion to reopen and a stay strategy, because older orders are often what triggers quick detention. If your history includes an arrest, obtain certified court dispositions and run the facts through immigration categories with counsel. Many state expungements do not eliminate immigration consequences, and crimes like theft, fraud, or certain assault-related offenses can be treated as crimes involving moral turpitude depending on the statute. If you have a credible but unresolved asylum case, understand how that interacts with a marriage case in your jurisdiction and whether a termination or remand is advisable before adjustment. If you have DACA or TPS and traveled on advance parole, know that a parole entry can sometimes supply the admission or parole needed for adjustment, but the details matter, and so do timing and jurisdictional policies. If you have any prior interaction with immigration court, call the EOIR automated line to verify whether proceedings exist and what the last action was, because many people discover a case only when a fingerprint match brings the file forward. Because many detentions are triggered by police interactions that begin with something minor, develop a calm, lawful plan for those moments. Keep your driver's license and registration current, fix broken lights, avoid driving if your license is expired, and carry a small folder with your state ID, a copy of your I-797 receipt notices, your attorney's card, and a one-page rights card. If you are stopped, provide ID as state law requires and remain polite. You generally do not have to answer questions about immigration status, and you can say you wish to remain silent and speak to an attorney. Never present false documents and never lie. Misrepresentation can turn a manageable situation into a permanent bar. If officers come to a home, ask them to show the warrant under the door. Do not open unless the warrant is signed by a judge with your correct name and address. If they have only an administrative ICE warrant, you do not have to let them in. If you are taken into ICE custody, family should obtain your A number. Use the ICE online detainee locator to confirm location and contact counsel immediately. Many people are eligible for bond or parole based on equities, and judges often look for steady employment, family ties, lack of dangerous criminal history, and a viable form of relief. The faster you provide organized evidence, the better your chances of release while your case proceeds. Inside immigration court, do not miss hearings. Update your address within 5 days of any move using EOIR 33 and keep certified proof. At the master calendar hearing, your attorney can ask for time to pursue a pending I-130, to file a motion to reopen an old order, or to seek prosecutorial discretion, and later, if the I-130 is approved and you are eligible to adjust before the judge, the court can adjudicate adjustment, or, in some districts, terminate proceedings so USCIS can. If adjustment is not possible because of an entry without inspection or other bars, explore cancellation of removal for LPRs or non-LPRs where the facts fit. 212H, waivers for certain criminal grounds when applicable, VAWA-based options if there is abuse by a U.S. citizen or LPR spouse, and if you fear harm abroad, asylum or withholding if filed within deadlines or linked to changed conditions. In every path, timelines, documentation, and consistency are your allies, and a credible, quiet presentation often outperforms dramatic narratives. There is a broader civic question running through all of this. A legal immigration system depends on voluntary participation. People file, appear, and tell the truth because they believe the process is designed to reward compliance. And when the act of showing up becomes the riskiest moment in a person's case, participation erodes. The goal of this analysis is not to tell anyone to avoid the system. It is to teach you how to engage with eyes open so that you can protect your household while still pursuing the status you qualify for. That means you keep filing the right forms with complete, truthful answers. You keep attending interviews if counsel confirms the risk is manageable. You keep building ordinary evidence of a shared life, leases or mortgages in both names, joint bank accounts with real activity, tax returns filed together when eligible, insurance policies naming each other, travel records and photos with captions from different times, and you add a safety layer. A same-day bond strategy if you have a known vulnerability, a communication plan for children and caregivers if a stop turns into a hold, a small savings buffer for legal fees and bond, and a list of documents in a Go folder at home and in a secure cloud file so your spouse or lawyer can act quickly. It is also important to correct a few loud myths so you are not led by rumor. Myth 1 says, marriage to a U.S. citizen protects you from ICE, which is false. Marriage can create eligibility to apply. It is not a shield. Myth 2 says, if you filed, you have legal status. Also false. Receipts prove filing, not status, unless you filed an application that itself grants a period of authorized stay. Myth 3 says, USCIS and ICE don't talk, which is outdated. Information sharing is routine. Myth 4 says, if you have no criminal record, you cannot be detained. Wrong. Civil grounds can trigger proceedings. Myth 5 says, a lawyer can guarantee you won't be detained. No lawyer can promise that, but a good lawyer can lower risk and build a plan for release and relief. If you are a U.S. citizen spouse reading this and feeling the floor wobble, there are concrete things you can do now. Verify that your own tax filings are current and that your income meets the I-864 thresholds for your household size. Arrange for a joint sponsor early if needed. Compile proof of U.S. domicile if you've been abroad. Keep original civil documents in a fireproof folder and scans in shared cloud storage. And rehearse with your spouse the timeline of your relationship so your interview is consistent and calm. If counsel flags a real risk, like a prior order, have a motion to reopen packet and a stay request ready so that any contact with ICE is met with action, not panic. If your spouse must drive for work, ensure the car is registered and insured, the license is valid, and lights are working. If you have children, list emergency contacts at their school and keep notarized caregiver authorizations in your file in case you need a friend or relative to pick them up. On short notice, most families will never need these tools, but the ones who do will be grateful they prepared. None of this changes the fact that many people win their marriage-based cases every single day. Field offices approve I-485s, consulates issue IRCR visas when policy allows, and families move on to renewals and then to naturalization. The system is not closed. It is stricter, more data-driven, and less forgiving of assumptions. The best response is not fear, it is discipline. Know your facts, organize your evidence, tell the truth, travel wisely, and build a plan for the small chance a routine moment becomes pivotal. Immigration Update Desk will keep translating what we see, policy memos, court decisions, on-the-ground reports, into practical steps you can use. And if your situation is complex, consider investing in a focused legal consultation rather than relying on viral advice. This is educational information, not legal advice, and individual facts matter. But the central message is steady. Doing it the right way still works when you pair compliance with awareness and, while the current environment has introduced new risks at ordinary touchpoints, it has not erased due process or the many forms of relief that allow families to stabilize. Take a breath, make a plan, and keep moving forward with your eyes open, because clarity and preparation are the antidote to a system that sometimes feels designed to surprise you.